guys, nice to see you again. This is the Lincoln Lawyer. Thanks for watching. And I am at Lauderdale by the sea on the beach. One of my favorite places to hang out. It's nice and quiet. Not too many people. Peaceful place to chill, have a smoke, have a drink, whatever. And today, topic of discussion is going to be basic asset protection principles. Things you just need to be aware of. All right, so let's begin. First of all, no state is going to protect you or a debtor against any government debt, government lien, tax lien, child support, or a divorce decree. Divorce division decree, okay? So you need to understand what can be protected. First of all, that is business assets, investment assets, personal assets from business creditors, personal creditors, generally not the spouse, but there's a divorce decree, but you can still protect your divorce assets elsewhere. But, you know, they pretty much got you there, and they can force you to disclose, they can force you to return assets. There's all kinds of powers a divorce court has. So what's the solution to that? Well, shit, probably don't get married. I don't know. Let's get into this. States need to protect, generally most states do protect, basic assets of every person living within that state, such as the home, homestead, vehicle, wages. Some protect furniture, personal assets, stuff like that. Some don't protect the full homestead, the full home, the full value of the homestead, but a certain amount, up to 500K, up to 750, whatever. But if your state doesn't protect sufficiently your assets, then you're in the wrong state. You need to get the fuck out. I mean, why would you live in a state that doesn't give a fuck about you? They don't give a shit if you lose your assets. I mean, if you live in that state, get out. That's as simple as that. So that's all I can say about that point, okay? So law is going to protect some of your assets, you know, basically, and that's fine, all right? Liquid assets, bank account, all right, should be kept to a minimum. That is the easiest type of asset to seize. Bank garnishment, they don't even have to notify you in many states. They just file it in whatever state they're in, and then file it in your state, or they can file it in your state. They don't have to notify you and send it to the bank. Boom, your assets are frozen. You are fucked. So be careful with holding liquid assets. You should not have too much. You really just need the minimum to run your life. Liquid assets, bank accounts, are very easy to seize in most states. Some states, they don't have to give you notice. Other states, they can send notice to some old address and claim they gave you notice. It doesn't matter. They can still get a judgment from a court, send that judgment to your bank. Once they find your bank, and boom, your assets are frozen, then you gotta litigate. You owe whatever amount you owe of the debt. You don't owe, you gotta argue with a judge, you gotta prove it, blah, blah. And you probably end up paying something. You're probably gonna end up with a settlement paying some part of the debt. So you need to understand, liquid assets should be kept to a minimum. You can keep liquid assets hidden, well hidden in cash. Obviously, a lot of people have cash. Not really something that I strongly recommend. But now you have crypto. You have plenty of places you can store crypto, cold storage. You know, you got a USB micro card. You can have all the crypto you freaking want, multiple cryptos hidden in different amounts, different areas. Safety deposit box, buried, whatever, with friends, family, hidden anywhere. You can have prepaid credit cards to whatever amount you can purchase. That's pretty much untraceable. You can't find that. You can't get it back. So that's fine. You can have the liquid invested in a asset that is stored in an LLC that is difficult to reach. All right, so business accounts, maybe separate different accounts, brokerage accounts, as many accounts as possible. But obviously, these are all public and these are all seizable. So you got to be careful with that. So try to have as many accounts in the name of an LLC, business accounts, or a trust. So that is one way to deal with liquid assets. But generally, the best way is just to have the liquid assets invested somewhere that is earning passive income. That's the point of life. All right, you want to earn passive income, and it's business assets, and it's stored in a separate entity that is difficult to find, if not impossible. And pretty much that's the best protection you can get with that. Okay, so on that point, Obviously, you want to control the assets, but not own them, not have them titled in your name. That's pretty much the goal of asset protection that we're talking about here. So if opposing counsel, if the creditor's counsel can't find the assets in your name, then obviously you pretty much don't own them, and there's no way they can pursue you for those assets, okay? So obviously this is nothing new. Everybody knows this. You know, a lot of criminals, mobsters, etc., title assets in a relative's name, a spouse or child, relative, anything, whatever, fictional person, fake ID, whatever. So this is an old scheme, old situation, nothing new here. Now, secrecy is a part of the strategy. So just so you understand, all right? So once you have an asset hidden somewhere, retitled in an LLC, in your freaking prepaid credit card, crypto, you don't want to tell anybody about it. I have a freaking USB drive with $1 million of crypto on it in my house. You don't want to tell people about it, okay? It's very simple. If you have an LLC, don't tell people you own the freaking LLC with this certain asset in it, okay? That makes you a target. This is basic, but people don't understand this, all right? If possible, you want that asset removed offshore. That makes it much more difficult to seize. There needs to be a whole separate litigation. I've talked about this in other videos. It's almost foolproof to remove an asset offshore. But anyway, generally onshore, you want an asset owned by an LLC, anonymous LLC, or a trust. That is generally how we do it. So I have discussed this in other videos. Basically, it sounds, you know, it is just like it sounds. An LLC is anonymous. Your name is not listed anywhere in ownership records. That LLC cannot be traced to you. And in any public records that a creditor's lawyer goes through, so they hire an asset search company, they're not going to find this particular LLC as belonging to you. And so that asset is not yours. Very simple. And a trust-owned LLC, in some states it's required. If some states require a lot of disclosure when forming an LLC, like who the members are, who the managers are, blah, blah, blah. If you don't want to appear as an officer of a particular LLC or a company, then you will definitely want a trust company. So the way around that generally is the multi-LLC structure that I discussed in other videos. So an LLC owned by another LLC in another state, that makes it much more difficult to seize. So basically a trust is used as the member of an LLC. It's a cheaper alternative, but it's not as efficient alternative because the agent is still going to be public, and the agent, the registered agent, is still going to have to disclose your identity if you need to be found, if you need to be sued. If somebody knows that you own the LLC, there is a way to get to you through that registered agent. Otherwise, the records are not public of the LLC ownership that is owned by a trust, and that's fine. The records, public records, only show a trust. Nobody knows you own the trust. It's a certain way of recording ownership of an LLC. Sometimes it works, sometimes it doesn't. So it's a little bit iffy. Some states aren't crazy about it. Some states don't allow it, but I've done it multiple times and it's worked every time. So, you know, it's a certain strategy that hides the name of the owner and the name of the trustee, so that's fine. But the multi-LLC strategy, it works every time. I mean, that's normal. That's a common strategy. You have a holding company, parent, and a subsidiary in another state that owns a particular asset, so that is perfectly fine. I've discussed this in other videos. Please look. So that's basically how that works. Next, another strategy is equity stripping. This is a very common strategy. This is basically encumbering an asset with a lien or multiple liens. Obviously, real estate, as soon as you buy real estate, there's a lien on it, you know, 75%, whatever it is, there's a lien on the freaking real estate. Generally, equipment will have liens on it. Inventory will have liens. Pretty much any kind of asset can have a lien on it. You know, you can pledge that asset for a loan, for credit. It can be a county lien with the county recorder on real estate. It can be UCC lien. Easy to record, this is fine, but generally speaking, it needs to be a legitimate lien. You can't just have, you know, a friendly company put a lien on it and record it because it may be checked. You may not be able to get away with it. I would say 7 out of 10 times you can, even if it's a bullshit lien, but I do recommend a legitimate lien to be recorded publicly. And if there's a public lien on an asset that you can be found to own, or your company that is known that you own, that owns that asset, and there's two liens on it, and there's pretty much no equity, little to no equity, nobody's going to pursue that, okay? So that's a way of asset protection. And generally, you really should have any substantial asset should generally be encumbered by a lien, even if it's a HELOC, home equity, line of credit, okay? This is the best kind of lien, which you don't pay interest on until you actually withdraw that credit, that you actually borrow some part of it, then the interest starts rolling. So there's all kinds of different liens, but basically that's the crux of the strategy. Next, you really need to understand inside-outside liability of an LLC. All right, so if you're a sole member, or there's multiple members, you have a partner, 2 partners, 5 partners, whatever, you have inside liability where the LLC actually commits the tort or whatever the business transgression and is sued. The LLC is actually sued. Then your personal assets, all the members' personal assets, are generally protected unless the veil is pierced, okay? So only the company assets are going to be at risk in that litigation. So that needs to be protected, and that's generally done with multi-LLC structures and removing assets to different LLCs, having a management LLC, having a parent holding company. So this is the whole asset protection strategy, that the company that is sued has little to no assets, generally a bank account that has only operating assets, and which can be removed, boom, very quickly and reestablished in another LLC. So that's inside liability. Outside liability is personal liability of each member in an LLC, okay? So you run somebody over, whatever, you hit somebody physically in a vehicle, you cause some kind of damage, you burn somebody's house down, whatever, any kind of personal matter. Let's say you're a physician, you commit some kind of malpractice, you are sued personally, and then that LLC interest that you own is subject to seizure because it's personal property, okay? So it is easy to protect that stuff. That's very easy. There's all kinds of clauses that can be inserted in an operating agreement to make sure that any interest that is seized, most states limit seizure, not to direct seizure of the interest and the creditor becomes a member, but generally they'll only have a charging lien on that interest and they'll be able to receive distributions. In most states, if you're not living in a charging order state, then you're living in the wrong state. So basically most states only permit a charging order where the creditor gets a judgment and they issue it to the LLC, and the LLC needs to pay any distributions to that creditor. That's easy to avoid, very easy. Operating agreement is going to have various clauses, anti-creditor protection clauses where the creditor can be bought out, the creditor may not receive any distribution, the creditor may have to pay taxes on phantom distributions that are not actually distributed but are retained in the company. So to make it very unwelcome and undesirable for a creditor to hold that interest, you can assign the debtor's interest to another person who's not a debtor as a substitute member. So there's all kinds of stuff, but all this stuff, inside and outside liability, can definitely easily be dealt with in most situations. So, but you need to understand the difference, okay? So wrapping up here, in conclusion, getting nice and dark, beautiful, chilly, about to go have a smoke. I am going to enjoy my Onyx right here. This is a present from my tremendous, fantastic, thoughtful father. This is a beautiful cigar, all right? So this is an Onyx. This is so good. I enjoy this. Every millimeter, I enjoy this. So, in conclusion, you want to have anonymous LLCs that are not listed publicly, owning most of your assets. So you control those LLCs, but not publicly. Keep it secret. Very important. From everybody. I mean, your family. You need to keep that shit secret. Because they'll blab to somebody, and you're still a target. So you need to be careful who knows what you own. You need to understand that. It's very important. So, if there's a threat on the horizon, you want to act, all right? Don't worry about fraudulent conveyance. Don't worry about all that bullshit, the federal laws hindering, delaying, defrauding creditors. Don't worry about that shit. Move the assets out. because you can either definitely 100% lose those assets, or you can move them out and make the creditor chase you. It's very expensive, very costly to prove. So just get those assets out, liquidate the assets if they're liquid, retitle them into anonymous entities, hide them, get them out of your name. Main plan, okay? Now, again, LLCs may be trust-owned, which are very useful, or they're multi-LLC structures that will own a particular LLC. Either one is extremely good. Trust-owned LLCs are fabulous because the trustee may resign secretly. It doesn't have to be public. May resign and emplace a substitute trustee, all right, a substitute trustee or a successor trustee, to take control of that particular LLC and remove those assets anywhere in a different state, retitle them offshore, liquidate them, sell them, whatever. It doesn't matter. So trusts are great, all right, because they are not public, and multi-LLC structures are great for businesses. So trust LLCs are difficult to deal with sometimes because third parties may not want to deal with them because they are so secretive, okay? So a lot of third parties may say, well, we don't know who owns it, beneficial interest, yada, yada. You know, there's a lot of mystery. They don't understand what that is. Banks may refuse to open an account. You may not get a loan for a trust-owned LLC. So these are great for holding companies that don't actually conduct business activities. So that's fine. But multi-LLC structures are excellent for anything, and you won't have any problems doing any business with third parties with that. So that is something you need to be aware of. And so I'm going to conclude it right here. And hope you enjoy your night. Thanks for watching. Be cool. Take care. Peace out. Subscribe, like. Bye.